Those are the live pictures from the Milimani Law Courts. We are seeing there the three-judge bench has just arrived. They have taken their seats, hence we're expecting then that the hearings will start anytime from now. And as is the norm, we will listen in because that's very, very important. It's the paramount agenda at this time. Justice Eric Ogola, Justice Anthony Mrima, and Justice Freda Bugambi are already in the of course, the courts, and I can see there that Justice Eric Ogola is already speaking. With the guidance of my team then, let's just cross over live and listen in.
We will do them separately, but the responses will be the same. So I'll call petition number 5, E562, H.E. Rigathi Gachagua versus the Speaker of the National Assembly, petition number E565 of 2024.
My Lords, may I request, with your kind permission, if we could allocate time so that we structure the presentation, and for our part, on the part of the respondents, we will respond together, and whatever time you will allocate to us, we will use together.
For our part, you will not, because we have to do the job of convincing the court. I believe we agreed for the first application. I believe the only one to deal with it. I will need 30 minutes to present my application.
How much?
30 minutes, my lord.
My lord,
may I comment on this one?
Yes, my lord, I say that's speaking for myself. I believe the other people will speak for themselves.
My lord, with your kind permission, for record purposes, I wish to bring to the attention of the court that we shall no longer be acting for the sixth respondent in this matter, and to that effect we have filed a notice to cease acting on account of the Supreme Court decision that determined that the president cannot be subject to civil proceedings. So in that regard, we will not be able to act contrary to an express court order, and we have therefore filed a notice to cease acting, and we ask the court to deem that to be a sufficient notice that the person named as the sixth respondent is now unrepresented in these proceedings.
Thank you, Dr. Kamotho. However, we are not inclined to do anything this afternoon except the business of the two files before the court. After that, we can take directions as may be necessary. Most obliged. As far as time allocation is concerned, this is how we'll allocate time. The main applicants will give you 15 minutes each. The main applicants, we will give you 15 minutes each. Supporters of the application, we will give you 5 minutes each. If you are supporting the application, we'll give you 5 minutes each. Respondents will give you 7 minutes each. Interested parties will give you 5 minutes each. Rejoinder by main applicants will be 7 minutes each. We ask the court assistant to observe time strictly.
Can you permit me to say something? My Lord, this is our first impeachment case since we became a republic. And impeachment cases are mixed up with all sorts of things like law, politics, security of the country, and etc. My very humble submission, my Lord, so far as possible, let people say what they want to say. It's a healing process. And coming up with 5 minutes, 10 minutes, 7 minutes, my lords, it does damage, not only to ourselves, but to the entire nation. It is the nation we are concerned about, all of us. When chips are down, we normally ask advocates take different positions when you have a matter before the court. But when it comes to impeachment cases, we are all concerned about the safety of the state, to save the state. Let people say what they want to say. There should be no limitation at all. That's my plea. And may I say to you most respectfully, I have come into this matter on behalf of Kituo cha Sheria. We stand for the rule of law, the supremacy, and for preservation of the state of Kenya. Let people say what they want to say. Let us not come up with 5 minutes, 10 minutes, or 20 minutes, and so on and so on. Thank you.
My Lords, Your Ladyship, I appreciate the matter before this honorable court is the recusal of the judges. But please, I urge you to be a little bit more flexible on the issue of time, particularly 5 minutes. My Lord, no council enjoys making an application for recusal of judges. It's a very weighty matter. So please allow us a little bit more flexibility.
Dr. Kamuna has submitted that he needs unlimited time, meaning that he can argue this case even until tomorrow. Mr. Mwite, how much time do you require for yourself?
I would say for those supporting at least 10 to 15 minutes. It's just relaxation that I'm asking for, so that the issues are wholly articulated.
My Lord, may I suggest that we stick to the time you have allocated us, and you have the discretion to allow anybody, including my learned senior, the Honorable P.K. Moite, any flexibility.
I think that's what we did last time. We allocated times, but we were flexible enough to add time whenever it became necessary. So with those submissions in mind, we'll give you the time allocations which we have given, but with the latitude to grant more should it be necessary.
Lord, I was going to request the court that because we are prosecuting this application, that we just say that officially so that I don't feel pressured. I have 30 minutes. This is the kind of case, my Lord, that if you do not argue it, inevitably, this case will somehow have to land to the Court of Appeal. I don't want anybody to accuse me I did not argue this or the other when I had an opportunity. 30 minutes will not bring heavens down. It is only 15 minutes to enable me to do the job, not for myself, for my clients.
Yes,
my Lord, if I may add something.
Here we go again, my Lord.
If I may add something, my Lord.
Time wasting.
Let me speak. This is a court of law. I respect you very much, counsel, senior counsel, and all the counsel here. But please let us appreciate that this is a court of law. And when directions are made, let's respect those directions. I'm making this direction. We have allocated time. Should it become necessary for one party to ask for more time, we will consider that. Thank you.
My Lord, the first application in which we have filed these documents in the file officially called petition number E015 of 2024 is an application dated 21st of October 2024. It is supported by an affidavit that has been sworn by this affidavit has been sworn by the Honorable David Munyi Madenge. It is further supported by a supplementary affidavit that is 21st, a supplementary affidavit of 24th of October 2024 by the Honorable David Madenge. My Lord, in addition to that, we have filed a bundle of authorities, which I believe that they have been furnished to the court. My Lord, looking at my watch, it is 3 p.m. I am certainly going to require some additional time, but let me start and see how best we can manage the time that has been allocated. My Lord, in the ruling that you delivered yesterday, you made a significant point that this is a matter of extreme public importance that deals with the most weighty issue that can be conducted, both with regard to the office that it relates to and to the issue of political succession. My Lord, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor Ben Nabweze, and when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. And my Lord, for purposes of this country, we are saying that for the 2010 Constitution, the matter before you, and that is why has informed the filing of these applications, is one that is an existential issue for purposes of the 2010 Constitutions. Your Lordships, I say that...
Your Honor, sorry for interruption. You have been muted. I am unable to follow proceedings. Okay. Now it's okay.
My thought process is affected now. Yes, my Lord. So I was submitting and saying that it is an existential issue for two reasons, my Lord. My Lord, most of us who are at this practice for 20 years are aware of two provisions of the former constitutions of Kenya. We used to have a sections 23 of the Kenyan constitutions, in which all executive powers were vested in the president. That position radically changed under the 2010 constitutions. We used to have section 30 of the constitution, in which parliament meant the president and the legislature. My Lord, those positions changed. The change of those positions, which is the submissions that we are making, the impeachment proceedings would have the consequences, if it goes the way in which it has gone, of effectively bringing back to life sections 23 and sections 30 of the former constitutions. Now, the second issue that I need to emphasize on the existential issues for the Constitution is this. My Lord, from the standpoint of the constitutions and to safeguard constitutionalism, there is these issues that is called security of tenure that certain offices enjoys, particularly with regard to the questions of removal. My Lord, the two offices that enjoys the greatest tenure are the office of the president and the office of the deputy president. My Lord, why is that the case? Because they are legally protected that to remove a president or a deputy president, you need impeachment. They are also secured by the electoral process, that those two people, to get to those offices, they must be voted into those offices by the people. My Lord, the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that, my Lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protections, like the office of the deputy president,
can be called, the removal can happen as we are alleging it happened in this case, my lord, the whole scheme of constitutional tenure and protection that is necessary to protect our democracy would effectively be null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, and that is why you write the constitutions, numbers must be controlled by law. If we reach a position where numbers cease to be controlled by the law, my lord, that would effectively have negated all the constitutional gains that this country has made. My lord, having made that point of the nature of the issues that you are dealing with, let me come to the issues before you. My lord, the petitioners, or in those cases, in those affidavits, in the applications, are saying a very simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of the strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My lord, the basis of that, since this is high writing, would be four. My lord, on the first issue is that the petitioners, and in the applications that they did, and is a subject of a ruling, they pointed out certain issues that brought into question the issues of the transparency, the proper accountability for purposes of the handling of that particular file. The affidavit is there. And then, according to the petitioner, that brought into them some doubts, the manner in which the handling was done as to the impartiality of this particular bench. The petitioners goes on to issues number two. They say that whereas they put in an affidavit setting out the reasons why there was a problem in the manner in which those issues were done, the respondents did not respond to challenge those particular set of facts. But my lords, the petitioners are saying that now that the respondents did not challenge their set of facts, the contrary issue that happened is this, that in the ruling that was read yesterday, we got a copy 30 minutes ago, there was a section that was called other issues. In the sections that was called other issues, the petitioners are saying that this court answered factual and evidential issues that relates to that application. And the consequences of that is that although they had been aggrieved, to them that would amount to this court entering the arena of conflict between the parties, the petitioners and the respondents. And my lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My lord, in our African societies, I've talked to my parents, I talked to Mr. Ogada, he said his community had the same set of issues. According to my community that I came from, in any those cases that used to be done traditionally, the first thing that would arise was this, and Article 159 says we respect our customs. It was to ask those who will be able to determine this case, are all the parties satisfied with this group of wazes that will be deciding the case? If either of the parties said, I don't know about yours. I said mine and Ogada. Mine is Kikuyu. I don't know. Ogada will talk for himself. My lord, let me have some peace. I think he wants to destroy my train of thoughts. My lord, so that the point I was saying, I can be happy. Ogada can defend himself what he told me. But my lord, I'm saying, at least for my community, that issue would arise. Does any of you have a problem with any of these wazes who will decide the issue. My Lord, if the issue arose that a party said, I don't want that mzee to be there or that other one, invariably, and this is communal justice, that person would pull out and get a mzee, another mzee that everybody feels comfortable with. So that, my Lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My Lord, when the petitioners were speaking about what they said they feel, like is the three-judge bench one in which they expect fair and square justice. That was a terminology in the case of Githunguri that we have attached on our submissions. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My Lord, why is that important? That, my Lord, is important because since Saturday of this week, in fact up to yesterday, but the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen me on televisions, where we have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges give to those particular orders. My Lord, that cannot create confidence because assuming it is not this case, every party, and we have very many cases here, if somebody, you are drinking him in a bar, says, no, you are going to lose that case before the persons we are appearing before. That, my Lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge, huge problem as to whether actual justice is possible. And it might actually be, my Lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. My Lord, if that is the case, and that may actually be the case before you, but my Lord, the scenario that is bad and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you are Ahmed Nasir told us, Oscar Sudi told us, Kamket told us, and all these individuals who are saying it was called drama. We are here for entertainment. My Lord, if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, my Lord, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of the supplementary affidavit. In this notice of appeal, your lordships, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. My Lord, the second last issue that I want to say is this. The issues, my Lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But you are told you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery as a result of the accusations and indictment that we are playing to the gallery. What effectively ended up being glossed over is the question of is the question of our own submissions. And my lord, the basis, and therefore the accusation, and we are saying we were not treated in a temperate and judicious manner. The petitioners and their advocates. Then, my lord, we go to the deciding for purposes of yesterday, the core issue. My lord, the core issue in our petitions, a number of them when it comes, would be the question, does the IEBC have the power to have authorized the president to say that Kindiki, I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination would...
I think it is important to just help my learned friend. We are not arguing the substantive application. It's a recusal. Let him stick
my lord,
to the
I'm
issues.
aware. Let him hear the issue and the answers. My lord,
just do the right thing.
My lord, the point I was making is this. One of the questions, I want to tie it with the 165. And the question is this. The question that would be arising is whether the IEBC without commissioners could have declared Honorable Kindiki to be suitable for this nomination in the letter they did to the president. My lord, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic would be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in contention, that people can be oblivious of such an issue. I need like 2 or 3 minutes. My lord, having said that, therefore, it is our submission. And as our Honorable Mita has said, nobody extracts any joy to raise this kind of an application because judges are legal colleagues. But my lord, the point that we also want to add for purposes of this application, this is contained, I believe, in the affidavit of my clients, is of course to point out to the issue. But the Honorable, the Deputy President, Rigathi Gachagua, by a letter dated 23rd of October 2024, did file a complaint against all your lordships. And this complaint was acknowledged by the Judicial Service Commission that it has been received. Then there is an issue that required disclosure. According to the petitioners, I wasn't even aware of this, I saw it today. According to the petitioners, is that there is a very close relationship between one of your lordships, the Honorable Judge Murima, and the Speaker of the National Assembly, who is the Speaker of the Senate, who is a member of here. That close relationship, according to the petitioners, is one that ought to have been disclosed so that parties could be able to make up their mind that are you comfortable? And we do that every day. I've actually not proceeded in a number of matters for some of the judges who are my classmates saying, Kibe was this, we were close, we were friends, are you comfortable? That question ought to have been raised. That issue was not raised, and as a result of that issues not having been raised and now having come to public notice, the petitioners are of the view that it would not be proper to be able to proceed in this matter. My lord, in conclusion, what I would like to add...
Before my learned friend concludes, I want you to be added another minute. Could he please, to assist us to respond, set out the nature of that relationship and where it is expounded in the affidavit?
Well, my lord, I thought that can actually come during the response, as I said.
The duty, the burden of establishing facts is on the person pleading the facts. So we want to know that relationship so that we can respond to it.
Yes, my lord, I have no problem whatsoever. There is a written affidavit. My lord, in paragraph 6 of the supplementary affidavit, It reads as follows: whereas I was not aware about the relationship between the Honorable Justice Mrima, who is among the 3 judges handling this matter, and the 4th respondent, that is Kingi, it has been brought to my attention that the Honorable Judge and the 4th respondent, Speaker of the Senate, are very close friends, as demonstrated as here under. 1, the respondent attended the wedding ceremony of the judge and they took a photograph with him. Number 2, in a post on social media, he indicated...
May I please, Your Lordship? May I
thought I should finish.
May I say something? May I say something?
Yes.
The position that my learned friend, Mr. Kipe, had taken, in my humble submission, was most appropriate. We are not here to destroy professions. Disclosing some of the details may not be the right thing at all. I think one should make a reference in a tactical manner, which your lordships will be able to appreciate of what is going on. I would respectfully say to you that this is an area where we have also to protect the judiciary, the judges and the magistrates, the judicial officers. I'm not very sure that we should have an in-depth account of what really one is complaining of.
Thank you, Dr. Kamino.
Let me explain that, my lord. There is a new affidavit that has just come online that contains some of these allegations. It wasn't there before, and that's why we sought. Now, you may proceed.
My lord, I think I agree with Dr. Kaminwa that unless, because as I said, I am not the source of any of this information or something that came to my knowledge, that I was sticking to what my learned colleague is talking about, unless there is insistence by my learned colleagues. My lord, I do not see the value of that insistence. I'll follow Dr. Kaminwa's position. It is stated in the affidavit. I will not say anything more on that. The respondents can say we can have a rejoinder when the issue arises. My lord, and the problem with these issues of somebody not continuing what they are saying is that you keep forgetting the last point. The last point, my lord, I think that I was making is this: that at the heart of an application for recusal, the authority speaks themselves, the one we have cited. I may not have time to go through them. Is these issues that are considered very important. Number 1 would be whether, on the basis of the accusation and apprehensions set out, would one party feel that their right to fair trial before an independent, impartial, and fair tribunal be upheld? The petitioners on that score are saying their rights under Article 50 to fair hearing, which is absolute, would not be possible in the circumstances of this case. Number 2, there is a question of the right to protection of law under our Constitution. That right to protection of law requires that for it to be protected, there must not be any doubt that that protections would be availed if it is deserved in accordance with the law. The petitioners again say they have reasons to believe, as a result of all matters taken into account, that their rights under Article 27 would stand violated. And my lord, the final issue, which is most important, my lord, the final issue, it could not really have been final, but I have to finish. My lord, the final issue that is critically important for this issue is the old notion, the old principle, that justice must not only be done, but must actually be seen to be done. In the circumstances of this case, it is our submission that apart from the real issues that the petitioners have, whether perceptions, whether substantial issues The petitioners are saying that, Your Lordships, they are unable to say that at the start of these proceedings, we were confident that these judges are capable of upholding our constitutional rights and to uphold justice equally between us. My Lord, we are most observed. Thank you for letting me conclude substantially on what we set out to do. We are most obliged.
Thank you.
My Lord, before the next speaker goes on, I think there is something we are doing and it is not fair to the court, because my learned friend was challenged by Professor Miguel to tell you what is the specific thing. Then they take the posture, assisted by the senior, that we don't want to go there. You cannot eat your cake. The reason they don't want to go there, my Lord, is because it is frivolous. Now, the misfortune we have is this. The world is watching these proceedings. They said we don't want to go there. And the typical person watching things, there is something very serious about the integrity of the court that they have raised. When, as a matter of fact, going by the list yet began is that the judge attended the wedding. The judge went to a restaurant. In one of the applications, they said the judge went to some law school. Clearly, we are being unfair to the court. We want to paint a picture, hiding that we don't want to go there, so that the world will be left with the impression that there is something terrible about this. My Lord, I think it is Lord Cromwell who said, if you want to paint a picture of me, don't embellish it. Say it, what and all. If they have any allegations now that we are broadcasting these proceedings to the world, if they have an allegation of any impropriety against any judge, they can't make the claim. For the gallery, then say, we don't want to go there. We submit it.
There's something wrong somewhere. What's happening? I am offended. According to wiki ears, is there something going on that is wrong?
That is the gallery. That's why. The gallery you're looking at. There must be something wrong with the gallery.
Yeah. My Lord, may I address my learned friend? May I make a comment on what my learned friend has
just
said?
a minute, please, Daktari. If you are using a gadget and your gadget could be causing this noise, please just set it properly.
May I make a comment, my Lord? May I remind my learned friend very, very respectfully. It is our duty to protect judicial officers also. And
they are not protecting the court, they are telling the whole world that this court is improper.
May I say what I want to say?
They can't have it both ways.
May I say what I want to say?
My Lord, when they apply for recusal, you don't apply for recusal of judges.
I think the proper way, Dr. Kaminwa, let parties submit according to the directions which we gave. And again, there is an application supported by affidavit. There are averments in those affidavits, and because some of those averments actually touch on us, but we cannot defend ourselves, we would be satisfied if you read them even verbatim, so that the world knows that these are your complaints against the bench.
My Lord, may I say something? May I say something? My Lord, as your Lordship is aware, at times when you are in a court, in open court, you will say
to Dr. Kabuna, please say what you want to say.
Yeah, you will say to a judge or judges that I have information that I would like that shows clearly that you should not hear this matter at all. Can we go to the chambers so that I can disclose that? I'm not asking that we go to the chambers. All that I'm saying, as lawyers or as advocates, we are also under duty to protect the judicial officers and to protect the institution of the judicial system.
I think that is okay.
Much more.
That is okay. I think one way of protecting judicial officers is by disclosing in open court like this what is there.
By being blunt.
Exactly.
I see. I am not with you, with respect.
My Lord, next time, I hope also, don't have to say you must do it within 15 minutes, which is what they were trying, then accuse you for not reading everything. Because I have not actually read everything, there are other issues I could also have read. But my Lord, let me read this. My Lord, hearty congratulations to my long-time friend. That was underlined by and the source is Right Honorable Amason Jeffa Kingi, EGH. The petitioners said the issue, and that is the issue that I picked during my submissions, that there is a long-term friendship between the judge and a party. That long-term friendship ought to have been disclosed. I said that. Then it goes on to say, on the occasion of the renewal of your marriage vows with your beloved wife, this is now the evidence that they are giving. You are a true testimony to the belief that spouses resolve to stick with each other through thick and thin, great things can happen. I wish the two of you the very best in this long journey and pray that God continues to bless this union and imbue with wisdom and patience that comes with marriage and family life. Hongera kakangu. And below there is a photograph where a gift is being given by the Honorable Mr. Kingi, Senator, to the couple of Judge Mrima and I believe his spouse. That is the annexure that was put by the petitioners in proof of the fact that there is a close relationship, a close friendship that under the law ought to have been disclosed, given that Kingi is a very important party for purposes of the case against the Senate, that he botched everything and has come here to defend those impeachment proceedings. I believe my job is done, and because that is all that it says. And that is the affidavit of the petitioners. Unless they need me to read something else, I can sit down.
The second applicant.
May it please you, my lords, my lady.
You are in another file, eh? Or we take it in another file or the same file?
Yes, my lady.
It's not in the same file.
Yes. I am in 509, where we have the application.
509 is in cohort 1, eh?
Yes, cohort 1.
Give us 5.
Your Lordship, with profound respect, permit me, Your Lordship, to indicate that we are arguing the application dated the 22nd of October, with a further affidavit, Your Lordship, having been filed this afternoon through the court's email. Your Lordship, from the onset, it's with heavy heart, Your Lordship, that we have to move you through these mechanisms. And that, Your Lordship, my submissions are the submissions of my client, and that I am just a vessel for putting across my client's case. Your Lordship, there is a notice of motion that seeks the recusal of this bench. The same, Your Lordship, is supported with an affidavit and an annexure. Equally, the further affidavit is supported by 2 annexures. In my submissions, Your Lordship, I will heavily rely on the facts contained therein. the 22nd of October, Your Lordships, my lady. I'll begin by indicating and relying on the Judicial Service Code of Conduct and Ethics Regulation 2020, and I draw the attention of the court to Regulation 47. Regulation 47, Your Lordship, states that a judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, 1, is a part of the proceedings, B, was or is a material witness in the matter in controversy, C, has personal knowledge of disputed evidentiary facts concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has personal interest or is in relationship with a person who has a personal interest in the outcome of the matter, F, has previously acted as counsel for a party in the same proceedings, G, is precluded from hearing the matter, H, a member of the judicial officer family, has economic or other interest in the outcome of the matter in question. A recusal by a judicial officer shall be based on specific grounds to be recorded in writing as part of the proceedings. Your Lordship, it is my client's, the petitioner's case, that this bench should recuse itself on the ground contained therein. Permit me to begin by indicating that yesterday when the court was delivering its ruling, it indicated actual bias on the part of the parties before you, Your Lordship. The petitioners were condemned in a wholesale, in disparaging language coming from the bench, a language that indicated prejudice or bias on the part of the petitioners. It was indicated by the bench, Your Lordship, that despite the heavy submissions, the authorities that we quoted, we were not addressing the bench, but addressing the gallery. It is so prejudiced, Your Lordship, that such perception on the part of the petitioners culminated into the court not even taking note of most crucial issues that we had submitted on. For example, despite the appeal that is now being launched, the court failed to take into notice of the question of delegated authority. It is to consider submissions, Your Lordship, that had it not been for the bias and the prejudice that the court has on the part of the petitioners, such would not have escaped the mind of the court. Your Lordship, further, the court made further remarks that they take great exceptions with the remarks of the petitioners. When the court indicates that they take great exceptions with the remarks of the petitioners, it's a prima facie indication that the court has descended into the arena of dispute, and that the court therefore becomes or takes a defensive approach in the manner in which the prosecution of the case is being conducted. Your Lordship, a judge must at all particular time be a solemn person, slow to anger, and of good temperaments. Your Lordship, the statement indicates that the court has taken a position as against the respondents, the petitioners. And the position is prejudicial to the petitioners and erodes their confidence to continue appearing and making submissions before this court. It was the observation of this honorable court, your lordships, that my client indicates that the court made further findings that the petitioners were not pursuing the urgency of the applications. What a reasonable man, a bystander, a fair-minded person, listening to these statements, internalizing them, will come to a conclusion that the court has taken a hard position on or against the petitioners. The test of a fair-minded person, your lordship.
My lord, we really hate to intervene, but my colleague, if he is added time for it, it's okay. But let him tell you how, yes, the ruling you issued will be a basis for an application that was filed long before that ruling.
Your lordship, if he may be patient, he'll have his chance to bite the cherry and respond in that manner he so thinks that he should. Your lordship, the application has also indicated that Justice E. Ogola is closely associated with his spouse, who serves in the Water Kenya Towers agency. The averments of our clients, your lordship, is that this is a matter that ought to have been disclosed at the inception of the proceedings.
You mean the judge is closely associated with the wife?
No, I didn't say that. No, I didn't say that. That is not my statement.
Yes, what is it that you said before? Repeat for the record.
May I repeat for the records so that the court may not again misquote me?
Okay.
Your lordship, the spouse of his lordship, one Florence Oluoch Auma.
You default to that issue?
Yes?
There's a disposition to that?
Yeah, there is a disposition to that issue, your lordship.
That Florence is the wife?
Yes, there is.
Paragraph?
Yes, paragraph 13 of the supporting affidavit, as read with paragraph 11 of the further affidavit. She holds a position in the Kenya Water Towers Agency, an appointment that was done pursuant to the Gazette notice number 7515 of 2013 for and on behalf of the presidency by Siopan Tuya. Your lordship, it may go on record that the sixth respondent who initiated or made this appointment is a party in these proceedings, and that the parties.
No, my lord, that's not factually correct.
I'm not getting you right, and I'm sorry for intervention.
Where are you lost, my lord?
Here. If I'm looking at the same document as you.
Yes.
The Gazette Notice 7515 was issued on the 7th day of June 2023 by Soipan Tunya.
That's correct.
Cabinet Secretary for Environment, Climate Change and Forestry.
That's correct.
The sixth respondent in this proceedings is who?
Is the president.
Then, where is the next one?
I'll get there. I'll get there. Your lordship, the cabinet under the constitution is constituted of the president, and the cabinet secretaries appointed there rather, and the deputy president of the Republic of Kenya. That Siopan Tuya is an agent of the presidency. Your lordship, one of the issues that was before the impeachment was that the deputy president, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance to that share agreement.
That is the reason why his client got impeached.
May I be given an opportunity to urge my case? They will be given an opportunity to respond. Even if you are itching, Mr. Nyamondi, take your call. Your Lordship, it is my client's submissions that Florence Auma Oluoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship, we have...
just a minute.
It is extremely unfair and unjust, especially for an advocate to mislead or what you have said to play to the gallery. Can you read paragraph 12 of the affidavit? So that he does, no.
Yes.
Let's hear it from him, where he says that the said board is chaired by the president, who has... So can you kindly do it properly so that you don't...
I'm sorry, I'm not an examination.
No, excuse me. No. Your honors, your ladyship and my lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they'll stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And we uphold the condescending nature of the respondents. Yeah. Everybody here has been instructed by a client either to speak sense or nonsense. So, that being the case, the condescending attitude is completely objectionable. And everybody should take their seat and use their time with the sense. If sense can only come from them, they do it during their time.
Thank you very much. Can I finish?
My Lord, may I be protected to urge my application and the respondents be granted an opportunity to respond?
This is what I was saying.
You will have your time, Worship, you are to respond.
But please, this is the application being presented. Let's not have a fee.
It has been served upon you.
My lady and my lords, just permit me to say one thing. Just one thing.
Your Honor, if I'm allowed to just say something.
Just a minute, Counsel. Just a minute, Counsel.
Let applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
Come to court and say that.
My lady and my lords, this is what I want to say. Just a minute.
Order. Can we have some order? Can we please have some order? Have you may proceed.
My lord, a judge is first an advocate and second an advocate. We are all here advocates. My plea is we conduct these proceedings in an orderly manner. As Professor Githu Muigai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can we just be slightly superior and deal with this thing in an intelligent way?
Sandegwa, use your remaining time to conclude.
I am most obliged, Lordship. It may be noted that, Your Lordship, that the chair of this board is directly appointed by the president, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose. And that the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I would wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
Ahmed Nasir is not the law.
Your Lordship.
He speaks not to the law. Ahmed Nasir has also an affidavit